well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam & Company. My name is Cam Edwards. Glad you're with me on the program today. We are guestless today. We might be guestless all week long, quite honestly. I'm having to do this show a little earlier than I normally do because of the intense heat that many of us are experiencing. I love my little shed office away from the rest of the house, but it is impossible to use the air conditioning and record stuff. And so with it being blazingly hot and gross across, much of the East Coast, but certainly Central Virginia, doing my show a little bit earlier than I normally do. And I don't expect guests to get up, at 6 o'clock in the morning to do a show with me. So, so again, maybe companyless. You may be keeping me company this week, but we'll get back to our normally guest-intensive podcast here before long. We do have a lot to talk about today. I was hoping to get some news over the weekend from the Senate parliamentarian about the Senate Finance Committee language, including the Short Act and the Hearing Protection Act provisions, essentially delisting suppressors, short-barreled firearms, and any other weapons from the auspices of the National Firearms Act. And we haven't seen any language come out of the parliamentarian's bird bath for the Finance Committee yet, but I do expect that could happen today. Senator John Thune wants to bring this bill to the floor of the Senate by midweek. I've seen that might get pushed back until Thursday. Obviously, the strikes on Iran have sort of upended the normal course of business on Capitol Hill. So it could be later today before we hear from the parliamentarian. Could be, I guess, as late as tomorrow. But I expect that we're going to be hearing from her imminently about what provisions coming out of the Senate Finance Committee will survive her rulings. And, we've already talked about the argument in favor of keeping this language in. Essentially, the National Firearms Act is a tax scheme, right? And it was a tax scheme designed to prevent people from being able to easily purchase these items. So if you get rid of the tax on these items, there's no reason for a registry, because the registry, as we've heard from Representative Andrew Clyde here on this program, who told us, listen, this is just basically a registry of who paid that tax. Well, if there's no tax to be paid, then there's no registry needed. So the registration requirement can go away as well. It's been a mixed bag so far, honestly, from the parliamentarian. There have been some portions of the One Big Beautiful Bill that have not survived her scrutiny. There have been some others that don't necessarily appear to be directly budget related that have. The proposed moratorium on state-level AI regulation, for instance, was okay with the parliamentarian. The way that was structured is that, and I guess why it survives the bird bath, why it is considered budget related, is that if states want to be eligible for billions of dollars in broadband build-out funding from the federal government, then they will agree to this moratorium. If they want to pass their own rules or regulations related to AI, they can, but they would not be eligible, again, for that broadband funding from the federal government. Again, that survived the bird bath. Now, whether or not it survives the final Senate bill remains to be seen. There's some objection there from some Republicans, both in the House and Senate, but the parliamentarian says it's okay. So to me, if that measure survived, then it should be a no-brainer that the removal of the taxes on suppressors, short-barreled firearms, any other weapons, that would survive the bird bath as well. Again, we've talked about this, and I wrote about this on Bearing Arms on Friday. The cautionary note here, and I don't think this is a reason not to move forward, but the cautionary note is that if you can get rid of these NFA taxes through budget reconciliation, then presumably you could also add to the NFA through budget reconciliation, right? So that does raise the issue of what happens the next time Democrats are in charge of writing a budget. Will they not only put suppressors, SBRs, short-barreled shotguns, any other weapons back onto the NFA? Would they add to it? Would they try to put semi-automatic rifles, so-called assault weapons, under the auspices of the NFA? Would they jack up the NFA taxes from $200 to $2,000? Again, if the parliamentarian says it's okay to remove items from the NFA through the budget process, then I think we can expect the Democrats are going to try to add to the NFA the next time they have the power to do so. Again, I don't think that's reason to not move forward. I think at this point, honestly, they'd be inclined to do that anyway. So you might as well move forward with protecting the Second Amendment as much as you can while you can. Speaking of protecting the Second Amendment, so since we last spoke, Rhode Island passed a semi-auto ban. Kind of. It's funny. The objection from the gun control advocates as well is it doesn't go far enough because it doesn't ban possession. Honestly, the House bill that they were hoping for didn't outright ban possession either. It did have a grandfather clause for existing owners of these banned firearms, but they would have first had to get some sort of certificate of compliance with their local or state police. That was dropped in favor of basically a voluntary form that they could acquire. But there was always a grandfather provision. And that grandfather provision exists in the bill that was passed by the Senate, ultimately passed by the House on Friday, and now goes to Governor Dan McKee for his signature. It's just that possession going forward is not banned outright, but there's still a ban on the sale and transfer of firearms, of these particular firearms. So, in essence, it really is a ban on the future possession as well. I think this was more of a distinction without a difference, quite frankly. But we know that the anti-gun Democrats are going to be back at it. They weren't happy with what passed the Rhode Island legislature in the final day of the session last Friday. So they're going to be back at it next year with a bigger, broader, more expansive ban. I would say not only in terms of who can continue to own these items, but what arms are actually banned. This was originally introduced as sort of the state-level version of the Go Safe Act, would have banned all centerfire rifles, semi-automatic centerfire rifles that are acceptable, that could accept a detachable magazine. It turned into more of the old-fashioned assault weapon ban, the sort of features test. I think they're going to be back with a more expansive ban next year as well. So Friday, again, the last day of the legislative session in Rhode Island, they were able to get that semi-auto ban across the legislature and onto the governor's desk, at least in some form or fashion. We also have seen the end of the legislative session in Maine. A wild and woolly session. For weeks, the Senate Democrats delayed and then, outright denied a public hearing on a red flag referendum that they were required to hold under state law. They finally did so at the last minute. Republicans had also pushed for a competing measure to be put on the ballot. That's not required. And Republicans waited, frankly, until I think it was the last day of the session last week to offer this up. Democrats ignored it. So there's not going to be a competing measure when voters go to the polls in this November. It's going to be, do you want to enact a red flag statute? Do you want to keep the existing yellow flag law in place? That was really, and again, I wouldn't even call that a win for gun control groups. It's on the ballot. We'll see if it actually passes come November. The only bill that is a gun control bill that actually passed out of the Maine legislature this year, according to NRA's Institute for Legislative Action, is a bill called LD 1126. So it was referred to as a ghost gun bill by anti-gun politicians. NRA-ILA says it redefines firearms under Maine law to include both finished and unfinished receivers. This definition change also explicitly requires that all finished and unfinished receivers, frames, and homemade firearms must be serialized at an FFL. This would hinder, they say, law-abiding Mainers' ability to build and repair firearms in their homes and require them to obtain expensive serialization on firearms and firearm parts. Also note that the quote-unquote ghost gun scheme does not address criminal activity in Maine. Instead, it serves a national agenda to ban homemade firearms, which have been a part of our nation's history since its inception. The bill passed both chambers, is now on the special appropriations table where it requires allocation of funding before it can get to Governor Mills' desk. That is also the case for a bill that I think is of benefit to gun owners that was passed in Maine. This LD 1867, which according to NRA-ILA prohibits the assignment of a specific merchant category code to the sale of firearms, ammunition, or firearm accessories, and provides a civil penalty for violations. This was introduced by pro-gun lawmaker Senator Matt Harrington from York, Pennsylvania. It protects gun owners' privacy, while additionally ensuring that bad actors cannot use credit and debit card transactions to create a gun registry or to block cardholders from making gun-related purchases. Now, that bill, too, has passed both chambers. It is now on the special appropriations table, so it also requires allocation of funding before it can get to the governor's desk. We'll see what the Democrat-controlled legislature does. I mean, again, they passed this bill So presumably they will also put some funding in, but might not be a bad idea to contact your lawmaker if you're a Maine gun owner and say, hey, don't forget to fund this thing. And by the way, while you're at it, don't fund that ghost gun law. Of course, there's another objection, I think, to these merchant category codes that NRA ILA didn't mention in their legislative summary, and that is these category codes don't actually allow anybody to peer into your cart. So the credit card companies, for example, they can see how much you purchased, where you purchased it, when you purchased, right? But that's it. And they're supposed to determine from that limited information whether something was a suspicious transaction that should be reported to the federal government. So what do you think is going to happen here? I mean, if these credit card companies are wanting to avoid liability, they're going to over-report, right? They're going to anything that to them seems excessive. Well, you spent $500 at a gun store yesterday, and then you spent another $500 at a gun store today. That's suspicious. Let's report it to the federal government just to be safe on our part, right? This is going to raise so many false red flags and subject gun owners to witch hunts, while frankly taking law enforcement's attention away from real threats. So this isn't just an attack on our Second Amendment rights. It's an attack on common sense. And frankly, I think it weakens national security. But that's not going to stop the anti-gunners. Now, there were a couple of other good bills that were passed in Maine as well, according to NRA ILA, LD 1322, a bill that directs the Department of Inland Fisheries and Wildlife to expand youth hunting seasons as well as outreach initiatives to increase youth participation in hunting. That has been signed into law by Governor Janet Mills. LD 1174 has also been signed into law by Governor Janet Mills. This is a law that will allow FFLs to have liability protections when they enter into voluntary firearm hold agreements with veterans and first responders, which NRA ILA says will increase the participation of FFLs in assisting those in need during a time of crisis. This bill, again, already signed into law by Governor Janet Mills. Now, I have to go, I got to say, I have to go take a look at this because the way NRA ILA wrote this, it seems like those voluntary hold agreements are only for veterans and first responders, as opposed to anybody that would like to use this, right? And I got to say, the Maine legislature's website is awful in terms of actually trying to figure out what passed and what the language was. So I've not been able to actually take a look at this bill, but I have no issue with allowing first responders or veterans to enter into these voluntary hold agreements. I just think that should be open to every gun owner in the state of Maine. Again, if you've got somebody in crisis at your home, you need to get rid of your guns temporarily, but you don't want to get rid of your guns forever. You just need a safe place to store them. You're going on vacation for a couple of weeks. You don't want to leave your firearms alone in the house, unattended. There are lots of reasons why these voluntary programs are much better than things like red flag laws. But again, they need to be as widely accessible as possible to as many gun owners as possible in order for them to work as well as they should. So those are the good bills. Now, and the bad bill that got signed into law. There were also a number of gun control bills that did not make it far in the Democrat-controlled legislature, which is, again, worth noting. As NRA ILA reports, LD 677 would have created a backdoor ban on commonly owned firearm parts by redefining a machine gun to include any semi-automatic firearm that includes parts that can, quote, increase the rate of fire. LD 1109 sought to ban standard capacity magazines in Maine, would have banned the possession, sale, manufacture, or transfer of magazines that exceed 10 rounds. And LD 1743 would have added some gun-free zones in the state of Maine by allowing municipalities to ban guns within their municipal buildings, municipal meetings, and voting places, which, as NRA ILA points out, would have violated Maine's longstanding preemption laws and disarmed and disenfranchised law-abiding gun owners. I don't think it would have violated the preemption law because it would have issued a carve-out, right? It would have weakened the firearms preemption law. And that has, again, been a big to-do item for the gun control lobby for the past couple of years. I mean, they basically rescinded it entirely in the state of Colorado. looking to weaken preemption anywhere they can. And again, once they get that nose under the tent, they just end up going for more. So all things considered, not a bad session in Maine, especially given the anti-gun majorities that exist on paper anyway in the House and Senate. It could have been a lot worse. We actually got to see some good bills passed. And most importantly, now we've got the time and we've got the ability to educate Mainers on the dangers in this red flag referendum. And the way that the Democrats handled this referendum, I think, is reason, an additional reason to vote against this measure. Remember, they didn't want to hold a public hearing. They were basically shamed into doing so, despite the fact that state law required it. When Republicans and Second Amendment advocates wanted to bring forth a competing measure, Democrats said no. You don't get to choose between expanding mental health access, expanding mental health programs, particularly in rural Maine, or a red flag law. It's either the red flag law or the existing yellow flag law. That's it. That, I think, alone is an argument, again, in favor of keeping the status quo in place. And again, next year, going back and trying to shame Maine Democrats into expanding access to mental health care, particularly in underserved parts of the state. That is a much better way of dealing with the dangerousness of individuals by trying to make them less dangerous, by trying to give them the help that they need, instead of, well, you know what, let's just take their guns away and we'll consider the problem solved. Red flag laws simply aren't effective. Even proponents of red flag laws say for every ERPO order that is authorized, for every 17 red flag orders, they say one suicide is prevented. Which begs the question, what about those other 16 individuals? Are they not a risk to themselves? So they didn't need to have their guns taken away from them in the first place? Are they a risk to themselves, and taking away their guns didn't stop the fact that they were a danger to themselves or others? Because to me, I mean, if your success is, well, 1 in every 17 times, this saves a life. Again, what about the other 16 times? And are there things that we could do that would be more constitutionally sound and more effective at preventing suicide and dealing with dangerous individuals than a red flag law? And the answer is, yeah, there's lots of things that can be done. And unfortunately, Maine Democrats this year didn't want to talk about them. All right, on to today's Armed Citizen story, our good deed of the day, and our recidivist report. Let's start there with a case out of Rochester, Minnesota, where a serial Rochester porch pirate is accused of striking again. Not necessarily, a lengthy, violent criminal history, but still, I mean, how many times does somebody have to get arrested for this particular crime before there are any sort of consequences here? 49-year-old Angela Mae Clemens is most recently been charged with 7 counts of felony mail theft. Criminal complaint says an Olmsted County Sheriff's Office deputy on patrol spotted Clemens in a vehicle, stopped next to a mailbox on the morning of March the 4th. Knowing that Clemens had prior mail theft convictions, that she didn't live in the area, the deputy made contact with her and eventually searched her vehicle. Among the items in her car, an envelope addressed to a rebate office in Wisconsin, a $10 check, numerous parcels containing eye drops, loafers, and other items, none of which belonged to her. In all, she was caught in possession of mail belonging to 7 different households, all of them Rochester, Minnesota residents. They were able to return most of the items to the victims. Some other property that Clemens identified as stolen was logged into evidence, according to court documents. And KROC says that court records show that Clemens was convicted of mail theft in Olmsted County as recently as 2022, 3 years ago. At the time, she was given a 19-month prison sentence, which was stayed in its entirety, and given 5 years probation for mail thefts in Rochester and Olmsted County. She was also convicted of mail theft in Olmsted County back in 2020 and 2018. And every time, it seems like she's gotten probation. Now, listen, does this lady need to be locked up for the rest of her life? No. I don't think this is worthy of a life without parole sentence. But should there be some kind of more severe consequences when you are repeatedly caught stealing other people's stuff out of their mailboxes? I would say yes. Why stay a 19-month prison sentence? Sentence her to 19 months. She's not going to spend 19 months in prison. We know that. time off for good behavior, she'll be out in less than a year. But that would still be more than what she's gotten now, which is essentially 0 prison time, despite, again, repeatedly stealing stuff that does not belong to her. Today's Armed Citizen story from Portland, Oregon, KATU in Portland, covering this defensive gun use, which happened last Thursday. Intruder hospitalized after being shot by armed homeowner during an attempted break-in. As I mentioned, this was last Thursday. Officers called out just before 1:30 in the morning. Homeowner told KATU News that the person he shot had been bashing on his door for about 10 minutes, claiming that he lived there. Homeowner said, "No, you don't," warned the guy that he was armed. 35-year-old Austin Mason Jones was shot by the homeowner after he broke through the door. And the homeowner told KATU that if police had arrived about 30 seconds earlier, they would have been able to make an arrest before he broke through the door. But when, minutes count, or when seconds count, help is only minutes away. Police say the homeowner cooperated with the investigations, knowing that the resident has not been charged. Again, I mean, if the homeowner's story is accurate, I would think that this individual has even in Oregon, has no worry about being charged. But I don't know, this is Multnomah County, so we'll take a wait-and-see approach and hopefully be able to give you more information as it becomes available. Finally today, our good deed of the day in the right place at the right time, willing and able to do the right thing. Evansville, Indiana, where a good Samaritan stopped a drunk driver from spending any more time behind the wheel of his vehicle. This was Saturday morning, 3:45 in the morning. Officers got a 911 call about an impaired driver. Caller described the driver as being, quote, all over the road in their white pickup truck, so that he had nearly collided with several vehicles while driving down the road on a city south side. Second caller then reported that the pickup truck was driving southbound on a street called Lodge Avenue, turned off, turned into another street, and that's when police say a, quote, good Samaritan was able to stop the driver, didn't say how, but was able to remove the keys from the ignition. When officers arrived, the police report says they immediately noticed signs of impairment from the male driver. He was placed into custody, taken to the local hospital, where he was found to have a blood alcohol content of 0.40, which is 5 times the legal limit. Police say the man so drunk that his intoxication could have been life-threatening, so he was admitted to the hospital. Then arrested on a preliminary charge of operating while intoxicated with a prior conviction, as well as operating a vehicle without ever having received a license. Whoops. Evansville police have not released the man's identity, and the Good Samaritan not being named as well, but in the right place at the right time, willing and able to do the right thing, not only to help this driver, but obviously anybody this driver might have come in contact with. Sounds like this individual has some issues here. Not their first time being arrested behind the wheel while intoxicated. Doesn't even have a driver's license, by the way. It's sort of like these gun-free zones, right? Yeah, you can have a requirement for a license. You can have a requirement for insurance. But if somebody wants to break the law, they're going to break the law. And then the issue becomes, okay, what are the consequences going to be? Hopefully this does not turn out to be a recidivist report here in the future. And this individual not only gets the help that they need, but gets some time behind bars to think about what help they might need and to sober up. All right, that is going to do it for this edition of Bearing Arms Cam & Company. I want to thank you, as always, for being a part of the program. I'm looking forward to being back with you again tomorrow. Again, probably a little earlier than normal. We'll get this posted, but the heat will break. The guests will return. And in the meantime, we're going to continue covering the latest Second Amendment news and information from all across the nation. Be sure to check out BearingArms.com throughout the day. We may very well again get ruling from the Senate parliamentarian about the language dealing with the NFA and suppressors, short-barreled firearms, and any other weapons. And, of course, we're watching what's going on in the courts, what's going on in state houses all across the country as well. So, we've got you covered there at BearingArms.com. All right, have a great rest of your Monday, as good as Mondays can be. We'll see you back here tomorrow. Until then, be well, be safe, stay cool, and be free.